Right. I'll wait for a few more attendees to come in before I give the introductions. Let's see. All right. Good afternoon or morning, everyone. Welcome to First Amendment Watch's July Public Forum, Media Investigations and the First Amendment. First Amendment Watch is a project of Arthur L. Carter Journalism Institute at New York University. Our mission is to document contemporary threats to freedom of speech, press, and assembly, and to promote a deeper understanding of the role these freedoms play in protecting our democracy. Today's guests include Gabe Rottman, the director of the Technology and Press Freedom Project at the Reporters Committee, and two Pullitzer-Prize-winning reporters who specialize in national security, New York Times reporter Charlie Savage and Washington Post reporter Ellen Nakashima. This event is co-sponsored with the First Amendment Coalition, an award-winning nonprofit public interest organization dedicated to advancing free speech, more open and accountable government, and public participation in civic affairs. This conversation will be moderated by David Snyder, FACT's Executive Director. Before I hand over the mic to David, I wanted to give everyone a quick overview of the controversy that spurred today's event. This spring, the Justice Department notified the Washington Post, CNN, and the New York Times that the agency had secretly sought phone and email records of phone records of 8 reporters in an effort to identify their confidential sources. The DOJ successfully seized phone logs for all 8 and email records for the CNN reporter. The reporters who were targeted include CNN Pentagon reporter Barbara Starr, Times reporter Matt Apuzzo, Adam Goldman, Michael Schmidt, and Eric Lischbel, and Washington Post reporters Greg Miller, Adam Entis, and one of our panelists today, Ellen Nakashima. Usually, investigators are supposed to notify newsrooms before seizing data to give them a chance to negotiate the scope of the disclosure. In these cases, none of the reporters knew that the government had been given access to their records. Today, we still don't know why the Department of Justice determined that advance notice was not appropriate. We also don't know for sure what information the department was looking for and who authorized the seizures. Based on the date of the seized records and the reporters who were targeted, the investigators might have been looking for sources who had information about the investigation into Russia's involvement in the 2016 election, but this is all still speculation. There is some good news. The new administration has said that it plans to tighten internal policies for when investigators can request journalists' data, when the DOJ can request journalists' data. Biden's Attorney General Merrick Garland has publicly announced that going forward, he will not allow investigators to use subpoenas, court orders, or warrants against reporters. All this is to say that we could be looking at a turning point in our history where the government finally puts into place real durable protections for journalists, but it's unclear if that's actually the case, and I'm being overly optimistic. I'll leave it to our moderator and panelists to determine how optimistic or realistic I'm being. Thanks so much, and David, I'll give you the floor.
Thank you, Soraya. I want to turn quickly to Ellen, Charlie, and Gabe, but before doing that, I wanted to just set the stage a little bit. We saw something pretty extraordinary and extraordinarily troubling with the events that Soraya has described. They're troubling by themselves, but they're also troubling in a broader sense because they strongly suggest that this kind of secret collection of journalist records may be becoming or have already become somewhat routine. In 2013, the DOJ secretly collected several months of Associated Press phone records, and they did this without AP's knowledge. So it was really an egregious overreach, and the public outcry that resulted from it prompted DOJ to revise its internal guidelines governing the seizure of reporter records, which we'll get into in our discussion. And then in 2018, the Justice Department revealed that it had secretly seized years worth of phone and email records from Ali Watkins, a reporter for the New York Times. And it remains unclear to this day whether the DOJ followed its guidelines in that case. And now we have these 8 reporters recently. The whole point of collection in these cases seems pretty clearly to have been to root out a reporter's source, the leak. these kind of seizures really strike at the core of some of the most important and revelatory journalism, and it jeopardizes a key relationship, that between the reporter and the source, that's expressly protected by journalist shield laws in most states. But those laws address subpoenas directed to journalists. What if the subpoena is directed at a phone company or an email provider, as it was in these cases? There, it's much easier for the government to avoid providing notice. They don't have to serve a subpoena on the reporter because someone else has the records that they want. And so the DOJ's media guidelines require that DOJ at least provide notice to journalists, except in really extraordinary circumstances. Are they following those rules? To me, at least, it's really not clear that they are. And without that kind of notice, we have kind of routine government-sanctioned secrecy, and that's a huge problem, not just for the press, but for the American people generally, who depend on journalists to root out corruption, wrongdoing, and other ills. I should get off my soapbox and to our panelists to explore this a little bit and try to tease out some of the most important points here. Gabe, I'd like to start with you. You've done just a terrific job of chronicling what's known and what's not known about DOJ's collection of information from these 8 reporters, and also similar past instances, for example, the collection of Ali Watkins records. And all of these cases implicate the DOJ media guidelines. Could you kind of give us a brief summary of what those guidelines do or what they're supposed to do? And then maybe talk about whether it looks like they were followed in these most recent cases or whether we can tell.
Sure, absolutely. So the basic background behind the guidelines is they actually date back 50 years during the Nixon administration. There were record number of subpoenas that were going to reporters, or an unprecedented number of subpoenas that were going to reporters, trying to force them to disclose confidential sources and other information. And because of public outcry about that, the Justice Department put in place guidelines that were finally promulgated in 1973, but the basic framework was in place in 1970, and the guidelines had sort of 3 main components to them that have been consistent throughout all iterations of the guidelines. One was high-level approval for seeking information from journalists in federal investigations. The Attorney General had to sign off on records requests. The second big check was that investigators had to use all reasonable means to find the information from non-media sources before going to the news media. And then the third point, which I think is probably the most salient to the current set of stories, is this idea of notice. Because if you're going to go after the records, if you're going to go after a journalist's records, if you compelled the disclosure of those records without giving notice to the newsroom and providing the newsroom and the news organization the ability to negotiate the scope of the records request or challenge it as improper, once the information is in the hands of the Justice Department, there's not much you can do if in fact the request was overbroad or improper. And so in one of the big things to note here too is that after the Associated Press incident that you mentioned, as well as a search warrant for actual email content from James Rosen, a Fox News correspondent at the time, in a leak investigation where the Justice Department alleged that he was a co-conspirator in order to invoke what's called the suspect exception under the Privacy Protection Act, a federal law that limits newsroom searches. After the outcry there, the Justice Department under Attorney General Holder revised the guidelines, and one of the key revisions was requiring a presumption of advance notice. So previously, the Attorney General had to affirmatively determine that notice to the affected journalist or news organization would not cause certain harms before providing advance notice. The 2014 and 2015 revisions to the guidelines flipped that presumption. So under the current guidelines, there's a presumption in favor of notice unless the Attorney General affirmatively determines certain narrow exceptions apply. And those exceptions are supposed to be quite narrow. In the language in the guidelines is that there's compelling reason to believe that advance notice would pose a clear and substantial threat to the integrity of the investigation, risk grave harm to national security, or present an imminent risk of death or serious bodily harm.
And that notice didn't happen. We know that that advance notice didn't happen in these cases, right, Gabe?
Yeah, and so fast forward to now, I think one of the topmost burning questions is why was advance notice not provided, and on what grounds, particularly given that the records sought dated back to 2017, that they were more than 3 years old. So, and also in the case of the New York Times, that it appears that the leak investigation itself was public knowledge that had been reported on before the Attorney General authorized this action. And as I say, that's the burning question that we would all like to answer.
So let's say that DOJ did not follow the guidelines, that they didn't get Attorney General approval, or that the reasons for avoiding advance notice were not sufficient. What happens then? You know, if the DOJ doesn't follow its guidelines, is there some way to force them to do that? Is there some punishment for not doing it? How binding are these things?
I mean, under the guidelines, they provide for administrative discipline, and it's unclear how that would play into this set of cases, if it does at all. There's also an Inspector General investigation that's ongoing that is looking into both the media seizures and the seizure of records from members of Congress and their staff.
In other words, there's not a lot of teeth to these things, it sounds like.
It's an internal policy, although for much of its history, the general sense was that it was a good one, particularly given that there's no federal shield law that would get courts in the mix.
Right. Yeah. I mean, those rules are terrific on their face, but I think one of the problems that I've noticed that we've encountered is that, you know, there's no backstop for it. There's no legal prevention. I want to get into with Charlie a little bit later some of the efforts to put some, actual laws, some statutory changes in place. But Gabe, I wanted to go to the June 14th meeting that your organization and various news executives had with Merrick Garland. And Garland said that DOJ would no longer seek source information from journalists in leak cases. And as I understand it, this would mean no subpoenas of any sort, whether secret or not. Is that your understanding of what Garland has said after the meeting with Reporters Committee and the news executives?
It does seem to be the expression of a blanket rule, and my boss Bruce Brown, the executive director of the Reporters Committee, was in those meetings, and he also gave comments to members of the press after those meetings, and they're online. So I'd also point anybody who's interested to take a look at those. And both Bruce and I had an article in Lawfare just last week, I think, where we go through all of what we know about both the record seizures and the Justice Department's response.
And so that's a really positive step. The DOJ has pledged that they're not going to go after the records, these kind of records, in that way. Is there any implication that there will be an actual policy change, that they're going to change the guidelines themselves? Or is it, at the moment, is this just sort of an oral promise, or is it clear?
The Attorney General has said that he would be issuing a memorandum by him. He said this during congressional testimony that would articulate the new policy, and so we're awaiting that memo.
Charlie, I wanted to turn to you. You're not one of the reporters affected by the government's collection of information here, but you have been covering it in great detail, shedding important light on the process, and so you have a unique perspective here. You did a piece on June 12th that kind of explored the issue of whether and how the DOJ's discretion in digging into reporters' records could be limited, by formally amending the guidelines, by simply saying it, as Merrick Garland and Biden have, or possibly by way of Congress, which could pass legislation limiting investigators' discretion here. Could you talk a little bit about those options and where things stand on that?
Sure. So this picks up naturally with what you were just discussing with Gabe. So the first thing that's going to happen is that Merrick Garland is going to issue a memo to all the U.S. attorneys' offices and assistant U.S. attorneys around the country saying no more using subpoenas and warrants or compulsory legal process to get reporters' information in leak investigations in a search for their sources. We expect that to happen this week. He has, however, said in publicly in a Justice Department readout of one of those meetings with editors that the next step and intent is to change the regulation so that this policy will be codified. That just takes longer than a 2 or 3 page memo that just says, as a matter of policy, you're not allowed to do this right now, which of course is easy for the next guy to revoke. And the next attorney general could also revoke the eventual changed regulation that is envisioned here. So the strongest and most difficult policy barrier to this kind of intrusive leak investigation technique that goes after reporters sourcing information via their cell phone records or their emails would be a change by law. Of course, it's hard to get anything through Congress. Senator Wyden has introduced a bill called the Press Act, which is an acronym that stands for something or another, but the notion is that it would ban at least no notice seizures of records and require some advanced negotiation, which would therefore give an opportunity for news organizations to challenge an intended seizure of reporter records in court, rather than just learning about it after the fact when it's a fait accompli. So that's weaker than what Garland and Biden are talking about, which is a flat, bright line ban on the practice, but it would still be a significant increase in press protections as a matter of law, rather than as a matter of executive branch grace, which is what we're talking about now. Nevertheless, this change that Biden announced and Garland seems to share and is implementing is a big deal. It is even if Congress never passes a law, it is a sea change in how the Justice Department handles these sorts of investigations under recent presidents of both parties. And I think the one thing that's missing from this conversation by way of context is why is it that this is becoming a bigger and bigger issue these days, that is under Trump and under Obama before him and under George W. Bush before him. Why isn't this the rules here something that's already well established and that we're used to, whether we like them or not, is just the way the country works? In the background is a change in how the Justice Department handles leak investigations in the first instance. For most of American history, it simply did not use criminal investigation, criminal charges to handle suspected leakers. There was only one successful prosecution of a government official for speaking out of school in the 20th century. That came in 1985, and it stood alone for another generation after that. There's a guy named Samuel Morrison. And it was seen as so unfair because obviously officials talk to the press without authorization every day in Washington and have for generations. That this one guy had gone to jail for that when no one else ever had, that President Clinton pardoned him near the end of his tenure. Just as saying this is ridiculous, as one person was punished for this thing that everyone does and no one ever gets punished for. But in the 21st century, after 9/11, and when there were started to be leaks about post 9/11 programs like warrantless surveillance and torture that really irritated the Bush administration, they made some changes in the Justice Department to begin to take leaks as a criminal matter much more seriously. They created a dedicated leaked prosecution task force of both prosecutors and FBI agents and took it out of the control of the Justice Department's counter-espionage section, which had always been in charge of referrals. And the counter-espionage section traditionally did not care about leaks. They were interested in spies for foreign countries, and they saw complaints about leaks in the newspaper for American audiences as impossible to investigate and just not as important anyway as going after spies. So they just would take leak referrals and just kind of put them in a drawer. And so the Bush administration broke that out and gave a certain group of people the sole job of going after leaks and trying to find out and put in jail who was telling the New York Times and other organizations about these kinds of post 9/11 secret programs. And that, along with the rise of 21st century communications practices that leave behind these electronic trails, text messages, stored emails, metadata showing who's been in contact with whom, which has made it a lot easier to winnow down a list of suspects by seeing who knew the secret and who had been in contact with the reporter. So this bureaucratic change and this technological change has combined to make leak prosecutions a much more normal thing that happens pretty much all the time now. It's gone from a never happens thing or once in 200 years thing to every few months, someone is getting charged with leaking and going to prison. And so that now that this is something that the Justice Department is in the business of doing, that is why suddenly prosecutors are wanting to get to reporters' emails, wanting to get to their phone records, because this thing that they never took seriously before or didn't take as something that needed to actually be investigated in a very serious and rigorous way, now they do. And so this change that has pushed this to this crisis, and now this backlash from Biden and Garland in response to the Trump administration's fairly aggressive use of this power, and maybe it's a violation of its own regulations in terms of the spirit, if not the letter of those. Who knows if William Barr or someone signed off on that or not? Apparently they did in some cases, but maybe not all. But either way, this has brought us to this point, and it's because so much is in flux against the backdrop of law enforcement and leaks of information to the news media in our current situation.
Yeah, it really does feel like perhaps a tipping point, and you really well articulated, Charlie, how we've kind of come to this point. Gabe, I wonder, as an advocacy organization that has been kind of tracking this issue really for all of your organization's history, what's your gut sense about whether we've reached a point where we're going to see some, really significant change? Maybe we've already seen that change, and that is the pledge by Garland and Biden to stop doing this. Do you think there's more in store? Do you think Congress might act? Do you think that there will be some result of this, maybe similar to what we saw after the AP leaks, some new protections that will be put in place?
Well, it certainly sounds like the memo and revisions to the regulations are something that's going to happen. And if it is a blanket rule, that really is a significant change in how the Justice Department does business. When it comes to prospects on the Hill, as Charlie mentioned, there is a bill that's been introduced by Senator Wyden, the Press Act, which is an acronym which I forget, and then there's also another bill by Representative Raskin in the House, also called the Press Act, but a different acronym. And both of those are particularly strong shield bills. There has been interest on the Hill in terms of passing a federal shield bill that would provide some protections and judicial review before journalists can be forced to disclose their sources or other information. And those initiatives have actually been, there's been significant bipartisan support. A shield bill has passed the House. I'm forgetting the exact years, but I think it was in 2007, it passed with like 300 votes, the 300 plus votes. And in maybe 2009, it passed by voice vote. But it tends to get hung up in the Senate, and there ends up being negotiations and discussions over, among other things, the definition of member of the news media, and then also exceptions for things like national security. And in 2013, the Senate Judiciary Committee marked up a shield bill. The last time there's been some movement in the Senate, but that ultimately didn't get a floor vote. So that's the history here. In terms of whether something could move, I mean, I do think that there's a sense now that when there's when there's a balancing test at play where, the government itself has to, has adopted internal policy that requires it to balance the investigative interest with press freedom interests, that isn't working. And particularly given the context that Charlie just laid out, that we're looking at, 18 journalistic source cases since 2009, depending on how you count, that the danger that this kind of thing will continue is pretty acute, and I think people get that.
And that's a really good time to bring in Ellen, who of course was directly affected here and has been doing this kind of work for a long time, work that depends on talking to people with the understanding that what they say isn't going to be attributed to them, that their identity won't be given to the government. Ellen, I know there's some limits on what you can get into publicly here, given the obvious need to continue protecting your sources. But can you kind of walk us through what happened here from your perspective, how you became aware of what DOJ says they were doing, and what's been publicly reported about what they did in your case, in the case of your colleagues at the Post?
Sure. I got a text message back in early May from a DOJ spokesman just asking me, say, how's your day going? I said, fine, what's up? And he said, well, are you in the office or working from home? And I said, working from home. And then he said, well, you might want to go into the office and check your mail. I said, why? He says, we sent you a FedEx package. We got your phone records. And I went, what? He said, we got your records, you, another colleague, and a former colleague, for a period from between April and July of 2017. And my mind raced, and I immediately thought, this must be a story that myself, Devlin Barrett, my colleague, and former Post reporter Adam Entis wrote in April of 2017 about how the FISA court had obtained a surveillance order on Carter Page, former Trump campaign official, which became a pretty controversial thing, that the FISA order had been approved for Carter Page. And that story, in fact, launched a leak investigation. So I raced to the newsroom, went and got my temperature checked and everything. The place was deserted, but I went downstairs to the mailroom, went to my mailbox, and I found a FedEx package. And in it was just a one-page letter. And because my colleague Devlin Barrett was out of town, he said, go check my mailbox. So I checked his mailbox, no FedEx package. And I was like, flummoxed, what's going on here? And anyway, as I was leaving the newsroom, I was driving back home, calling Devlin. I said, there's no package for you. And so we were racking our memories to figure out what's going on. If it wasn't the Carter Page story, what was it? And as I was driving, Devlin did some research, and he said, I think I know what it is. It might be this story that another colleague, Greg Miller, and Adam did in July of 2017 about then Attorney General Jeff Sessions speaking to the Russian ambassador, Sergei Kislyak, about campaign matters while Sessions was on the campaign and still in the Senate. And this was contrary to what Sessions had said publicly, which was he had never discussed campaign matters with Russian government officials. And that was what the story was about. Anyway, I'd totally forgotten about that story until I saw this letter and wondered whether this was the motivating factor. What it was in this letter was a one paragraph letter, just basically saying, pursuant to the statute 28 CFR 5010, you're hereby notified that the U.S. Department of Justice received toll records associated with my home phone, cell phone, and work landline. And that additionally, the court authorized an order to get my email metadata records for my work email, although no records were obtained. So my reaction was this is outrageous. The mere fact that the Justice Department had sought my records and those of my colleagues is outrageous. And to the extent it put any of our sources at risk, it's troubling. So sort of that in a nutshell is what happened back in May.
Can you talk a little bit more about what you said just there at the end, to the extent that it put some of your sources at risk? I guess talk a little bit about the overarching effect of this kind of collection on, your sources, on potential sources, on your ability to do what you do, which depends to some degree, to maybe a great degree, on the willingness of people to come forward and talk to you confidentially.
I want to go back to something Charlie said and noticed, which was that this is really a trend that began back in the George W. Bush administration, continued through to the Obama administration, and then into now, the Trump administration. And because it is something that is not confined to one party. It was carried out by both Democratic and Republican administrations. And anytime anytime it becomes public that there are leak investigations, journalist records are being sought, there is a chilling effect on sources. And that is troubling in two ways, at least two ways. One is sort of more obvious, one of the chilling whistleblowers who might otherwise have the courage to inform reporters of government abuses of law and policy. We might not have learned of the US government's warrantless surveillance program during the Bush administration if sources had not come forward to James Risen and Eric Lichtblau of the New York Times, or of the CIA's Operation of Black Sites, where torture was taking place, if sources had not spoken to my colleague, Dana Priest. And there is still another less understood way in which going after sources has a chilling effect that undermines our ability to operate as a free press. And it is that it greatly discourages sources who might otherwise take the time to talk to reporters like me and Charlie to share valuable insights about just the context for operations and policies and about the significance of developments that I might be hearing about, even if they're not necessarily disclosing classified information per se or some bombshell revelation, rather just sharing their wisdom and expertise that helps inform accurate and fair and nuanced reporting, which is so critical in national security stories.
How much confidence do you have, Ellen, just as yourself as a reporter, after Garland and I guess Biden's also pledged that this kind of collection from reporters won't continue? Do you think in your gut that this is, there really is a sea change afoot, that this trend that we've been talking about is going to taper off?
So, while Attorney General Garland may be acting in good faith and will enforce the policy of not seeking journalists' records, we can't be sure that some future Attorney General won't reverse the policy. I mean, as I said, after all, this is not an issue that is confined to one party. And in fact, my records were obtained once before in the Bush administration. Back then, didn't even use a subpoena. The FBI used something called an exigent letter, which is not even a legal process, and which the Department of Justice Inspector General criticized, and so FBI stopped using it. But I mean, with that exigent letter, they asked for 7 months worth of records and got 22 months. And that felt like a real violation and was really intrusive. And so when this happened a second time, how can I be sure it won't happen a third?
So I should pause here for station identification, as they say. In case you're just tuning in, we're here today with Gabe Rottman of Reporters Committee for Freedom of the Press and reporters Ellen Nakashima and Charlie Savage to discuss media leak investigations and the effect that they have on press freedoms. And the event is sponsored by the First Amendment Watch and the First Amendment Coalition. Charlie, I wanted to turn back to you to maybe try to bore in a little bit on the collection of your colleagues' information at the New York Times. Now, you weren't one of the reporters from whom information was collected, but you've been the one covering it. And give me 1 second. I had so in your one of the things your coverage highlights, I think, is that it's not clear if necessary approvals were sought within the DOJ, approvals that the media guidelines require before it sought records from your colleagues at the Times. And you wrote that on January 5th, when the Trump administration was still in control, it obtained the secret order, but that the head of public affairs at DOJ at that time declined to comment about whether the approvals were sought. Can you talk a little bit, if you have this top of mind, about what's known or not known about whether the required approvals under the media guidelines were sought in the instance of the New York Times collection?
Sure. And as a preliminary matter, when you bring up the January 5th order, so there's a second round of this, which is not about phone records. So you have to understand a certain complexity here, which is they obtained phone records fairly easily you don't need to go to a judge to do that. You can use a grand jury subpoena and you just get them if you're a prosecutor. To obtain email metadata, the equivalent of phone records, all we're talking about here is logs saying this person sent a message to this other person or called this other person at a certain time, but not what they said, not what the content is. Even though that's basically the same thing in the world of email and phone, the law is a huge mess in the United States, and it does not treat those two things the same. And so to get email metadata from a company like Google or Yahoo or Microsoft, the government has to go to a court and get a judge's order. It's not a full warrant. The standard is lower, but they still have to go to a judge as opposed to phone records where they can just do it unilaterally. And so on January 5th, they obtained, having already gotten the phone records of Times reporters, they obtained this order from a magistrate judge to get from Google their email records, because Google provides the back end support for New York Times corporate emails and newsroom emails. And that launched a long fight. Google did not respond for a month or so. In the meantime, the Biden administration took office. Prosecutors who were working on this case kept going and said to Google, what's going on? And Google said, well, we're not going to turn it over to you unless you tell the New York Times, because we have a contract that says we'll let you know if someone's asking for your stuff. And eventually the Biden Justice Department kept going with this, but did allow some senior executives at the Times, not newsroom people, to learn that this had happened, while at the same time gagging them from talking about it publicly or even to people in the newsroom. And so the fact that this spilled over from the Trump administration into the Biden administration, and in fact, it was the Biden DOJ that obtained gag orders on New York Times executives, has added a certain froth to this, and underscores Ellen's point that this is, these sorts of things can happen under administrations of both parties, even though we don't know that there was necessarily high-level political support for the gag orders. There's still a lot of murkiness about who knew what when and who was read in and who was notified. And the government is not particularly eager to open the kimono on that kind of internal deliberative process. But surrounding that order has been another thing, which is that we know, because we've seen the judge's order now, it's been unsealed. The judge wrote that he was persuaded, based on some kind of showing that the Justice Department made to him, that the gag orders, first to Google and then later by extension to these Times executives, was necessary to avoid letting the investigation be disrupted if it became public. And as you mentioned very early on here, that makes no sense, because we had written a front page story a year earlier about the particular leak investigation we think is in play here, involving Jim Comey and something in Russia. And so we are still fighting to see the filing to the judge that would lay out whether the judge was actually told that this was already a publicly known investigation, or whether they misled the judge by not telling him that and representing it as a big secret. And surrounding all of that is, well, what about the rules in the Justice Department's regulations? This is circling back to your question now. They say that when you're going to get compulsory, get reporters information to try to find their sources, it has to go through the head of public affairs, across his desk or her desk. It has to go up to the very, very senior level, attorney general or a couple of designees, head of the National Security Division, for example. And we know that in some of these cases, people close to Bill Barr have said he knew about it and approved it. And at least one of them, he doesn't seem to have known about it. And maybe that means John Demers, the head of the National Security Division, who hasn't talked about this, was the person who approved it instead, or whatnot. But from my vantage point, I think I would be surprised if there wasn't something that may have been observed in form, if not substance, in terms of, oh yeah, you can do that, as opposed to the really serious weighing of equities here that the regulations envision. But it's not entirely clear, at least in ours, that even the head of the public affairs at that moment recalls having seen it cross his desk. And so there's a lot of unanswered questions that hopefully Inspector General Michael Horowitz will dissect now that he has launched into this issue as something he's going to investigate.
Yeah, this issue of whether and how the guidelines were followed is one that I think comes up again and again, in part because it's a bit of a black box. There's no way to really know whether the processes that are laid out in the media guidelines have been adhered to. My organization has filed a lawsuit to try to answer that question, and we've not had much success. Gabe, I was hoping to turn back to you to talk a little bit about that issue. Has there been any discussion, do you know, about trying to make the process more transparent? Is that even possible? Having the guidelines is one thing, and it's great, but how do we know if DOJ is actually adhering to them?
It's a good question. We have a FOIA lawsuit that we filed after all this stuff had happened, and we'd submitted requests to see whether, in fact, actually the guidelines had changed at some point. Although we have there's no indication in the public record that they have. But Attorney General Garland at his confirmation hearing said that was his understanding as well. It's a good question, given that the process by which these crimes reports, the referrals from the intelligence agencies go through the Department of Justice. You're talking about an active investigation, and it would be great to have additional transparency into it. I mean, one thing that I would note is that after the Holder reforms, starting actually right around there, the Justice Department started to do annual reports on how the guidelines were implemented. And there are reports going all the way until 2018 that have been released, but we don't have reports for 2019 or 2020. And those reports are pretty fulsome in terms of the detail that they provide on how the guidelines were applied. But what you do see is that in most cases, the guidelines, when they're being used, are for voluntary subpoenas. So instances where you want to get outtakes from a broadcast station, and you ask for them, and they say we'll do it, but you've got to give us a subpoena first. So it's a key question. I mean, in terms of how to provide additional transparency, but I do also think that at the end of the day, you're talking about a legal landscape where kind of the controversy may be that all of this was within the letter of the law, right? So you've got phenomenon or dynamics like the move of the move of the newsrooms to the cloud, which then implicates all of these electronic communications privacy laws that Charlie mentioned, which really are hard to parse and are based on an obsolete understanding of how technology works. And so with that movement to the cloud, then the security of those records, the integrity of those records then rests in the hands of third parties. And then the other thing I would note too is that you also have a law in the books, the Espionage Act of 1917, which for 90 years was never used or was used in extremely rare instances involving journalistic sources. There was one contemplated prosecution of a news organization and reporter during World War II that didn't get past the grand jury stage. But the law, read literally and on its face, says that anybody who has unauthorized access to national defense information, which for our purposes we can say is classified information, and discloses it to somebody who's not authorized to receive it, violates the law. And that's the hook that is being used to pursue the journalistic sources for the unauthorized disclosure of national defense information. And so, it's important that we strengthen, the internal policy of DOJ and look at it legislatively.
Hi, I'm interrupting because it's around time that I want to get to some of the audience's questions. If anyone hasn't posed a question yet and would like to, there's a Q&A and it's open. You could just type it in. I'm going to try to get it to as many as possible. Thank you guys so much. I was listening to this and I've been, summarizing a lot of these things, pulling from both Charlie's writing and Gabe's writing, and Ellen, I've read all of the articles that possibly were the source of the Fed's investigation. I think that this really brought a lot of the questions to one place and got me to sit with it for a while. So I hope everyone enjoyed that as much as I did. The first question I wanted to, I pulled from the chat is from Jason Palladino, and it is for Ellen and Charlie. The question is, do you explain to sources that even when offering anonymity, there is a risk because of the DOJ leak investigations that their identities could become known without your knowledge, without legal notice? Have you noticed, if you did, have you noticed a chilling effect in what they talk to you about? Yeah, Ellen.
Typically, the sources I deal with are well aware of the risks of talking to a journalist. And I think I still remember Charlie way back when we were both trying to figure out what Senator Wyden meant by this secret law, and we were on the trail of that story. And when we were talk to sources, they would tell us, I'd love to talk to you, but I've got a family, a wife, a kids, house, and I can't risk that for to talk to you. And so, in a general sense, I think sources are already well aware without us having to spell out the risks. I think sometimes with sources, they want more assurances about the fact that their names will never be used. I've definitely moved to using much more secure means of communications like Signal, which does not leave a metadata trail that can be obtained by a prosecutor with a subpoena or deorder. And that's one way I try to be more protective of my sources. Charlie, if you want to.
No, I think that answer was pretty good. I associate myself with it.
Okay. This question is for Gabe. In your opinion, what responsibility, if any, do telephone providers or for that matter, email providers have to resist the kind of subpoenas that we talked about today? And if you do think they should resist, what are some creative legal strategies in addition to the contract stipulation to resist those kinds of subpoenas?
Yeah, so it's a great question. In this case, the cloud email providers, so in this case, Google appears to have done the right thing and insisted that it be able to notify at least some folks at the New York Times, and that's how we know about the gag that was applied to the senior executives at the Times. In the case of CNN, actually, it was interesting because that Barbara Starr's work email was administered by Warner Media itself, which is how Warner Media was served with the what's called a D order, the 2703 D order, named after the relevant statute for email logs. And that's how it trickled down to the general counsel. But the general counsel was also gagged under the 2705B order, which is also in the same law. And so that's how we know about these things. Google and Microsoft have both been vocal in terms of pushing back against the existence of these gags, which is part of which is really part of the issue here. When you were talking about the physical world, if you serve a search warrant on someone, you get the search warrant, they post it to your door, they hand it to you, they do the search. When it's a third-party electronic communications provider, both when you're talking about content and non-content, it's conceivable that you'll never find out. And so, there's an legal problem because it puts third-party communications providers in a tough position. On the one hand, you've got the government saying you can't tell anybody, and on the other hand, you've got customers. You may have contractual provisions, to provide notice. And the underlying legal question that really does need to be addressed is the laws that the Fourth Amendment approach typically taken to, certainly when you're keeping things in a filing cabinet, but even when you're talking about wiretapping laws and telephonic communication, that Fourth Amendment approach is broken down in the context of electronic communications and particularly metadata. And so there's this doctrine, the third-party doctrine, dating back to the 1970s that has been expanded to kind of say that if you give over your metadata, who you call when, for how long, subscriber information, if you provide that to a third party, there's no Fourth Amendment protection in that information, which has led to this state of affairs. And so the third-party doctrine needs to be addressed in this context as well, to provide the same kind of security in records held by third parties that you would expect if it was in your computer at home, on your phone, in a filing cabinet. And there's been some movement on that in the Supreme Court. There was a decision recently called Carpenter v. US, where the court held that more than 7 days of location information, cell site location information, can be collected without a warrant. And so the courts are grappling with this, but it's the third-party doctrine, and then there's also this additional issue of how revelatory metadata is, right? So when this comes up, the response is, well, it's not content, it's metadata, but as we're all carrying, very sophisticated computers in our pocket every day, the volume of that metadata is more and more revelatory of our activity. So those are the underlying issues that the providers are having to face and need to be resolved.
And is this contract element something that you think they intentionally did because of the increase in attempts to get third party or their customers' information, or is this like an accident, a coincidental accident? Like they're like, oh, it's great that we have this, now we don't have to hand this over.
Well, I can't speak for the time in terms of its contract negotiations, but but certainly, again, because of the legal dynamic that I'm talking about, where the third-party service provider gets an order saying, give us your records, and you can't tell anybody about it. There is certainly an incentive for news organizations to try and get best efforts notification, because of what I mentioned earlier. Once the government has the material, there's very little that you can do about it. So I think it's certainly that. I think it's certainly it reflects that reality, but then there's also on the tech side, there's a business interest in providing as much privacy as you can when you're talking about moving communications to the cloud. Absolutely.
There is another question. Hopefully we can get to a couple more, but in case, I'll try to combine two here. This is for Charlie, because I remember that you wrote a bit about Julian Assange in your last. We didn't talk today about the espionage, which broadly Espionage Act that doesn't apply to journalists who publish leaked information, but can apply to sources of leaked information, such as Julian Assange. There is a room right now for trying to also figure out what a journalist counts as, the definition of a journalist. And I think that Julian Assange is like this case that we're looking at as who counts as a publisher information. Where do you fit the Julian Assange story into the larger history that you outlined in the beginning of the panel?
Right. So the Julian Assange prosecution is very important in this context of an increasingly aggressive Justice Department putting pressure on the ability of reporters to do their jobs. And so the Assange, of course, was indicted for a hacking conspiracy, which doesn't have much to do with journalism, but also for the act of soliciting, asking for, and then publishing classified documents. The documents provided to him in 2010 by Chelsea Manning midway through the Trump administration. And that case, the second half of that case, the non-hacking conspiracy side of it, has alarmed press freedom advocates because it could establish a precedent that the journalistic style acts of soliciting and publishing government secrets can be treated as a crime in America. And this does not, you suggested that the Espionage Act, which is the one that makes it an unauthorized publication of or retention of secrets, doesn't apply to journalists. It's actually not clear. There's no special status for journalists per se in American law. So it doesn't really matter whether Julian Assange counts as a journalist or doesn't count as a journalist. Obviously, he's sort of an unusual person. But it's the action. Can this act be treated as a crime? And so on the face of it, the statute that dates back to World War I applies to everybody, which means it applies to journalists too. It's never been used to prosecute a journalist successfully, at least, or even charges all the way, because there's always been this sense that it probably violates the First Amendment, at least as applied to journalists. But that norm of not going there has prevented Justice Departments up until now from testing it. And the Trump Barr Justice Department didn't really care if this would damage press freedoms more broadly, and they decided to expand the hacking case against Assange to go there. And so if he is extradited right now, that's all tied up in court in London, and comes here, and the Garland Justice Department presses forward with the full range of charges that the Trump administration obtained against him, that will be a test case that could establish a precedent that what people like Ellen and I do as well could end up throwing us in jail. And that could obviously have an extraordinary chilling impact on the future of national security investigative journalism. Whether you like Assange or hate him is sort of irrelevant to the point we're discussing here, which is what the Justice Department is willing to do and then what it can do in this space, as in the space of this changing approach to leaks that we've been discussing here just in the 21st century. So I'm glad that the person brought up the Assange case, because I think so far the Biden administration's decision to press forward with it unchanged is very significant for storm clouds down the road in this area.
Right. Thank you so much, Charlie, and to Ellen and Gabe and David. David and I worked together on preparing for this panel, and you did just an amazing job moderating, really putting together everything and ordering it in a way that made great sense. This Public Forum is, I think, around the 6th of our event series. So we have all of our previous forums have been recorded and are available on our site. I'm going to paste the links in case anybody is interested in watching them. We have events. We have had events on court access that we also did with the First Amendment Coalition. Whoops, that's a question. That's not. A second. Sorry, guys. Here we go. These are separate links. Let me get this right. We had one on the Dominion lawsuits. We had one on misinformation and public trust. And we've also had one on court access and racial justice, where we talked about the George Floyd trial, and all of those are recorded, as this one will be. Thank you, everyone. And I really appreciate everyone for coming. Again, this was hosted by First Amendment Watch and the NYU and First Amendment Coalition. I hope to see you guys in the next series.